Hello everyone. Now we are going to deal with the second part of this Industrial Dispute Act 1947, which is going to where we will be dealing with the introductory part, where we are going to deal with the important definitions, and those definitions and terminology and terms are going to help us to understand what exactly Industrial Dispute Act 1947 is. So now let us look at the important terms and definitions. Now let us see what are the procedures of strike and lockout. So the procedure of strikes are, according to section 22 clause 1, no person employed in a public utility service shall go in breach of contract, right? So there are the conditions before going on strike. Without giving to the employer notice of strike, so the employee has to give notice to the employer as hereinafter provided within 6 weeks before striking. So there should be 6 week of time within 6 weeks before striking. Within 6 weeks, an intimation has to be given to the employer within 4 days of giving such, or within 4 days of giving such notice, or right, or within or within 14 days of giving such notice, right? Either within 6 weeks before striking, or within 14 days of giving such notice, or before the expiry of the date of strike specified in any such notice as aforesaid. So before the expiry of that before the expiry of the date of that strike specified in any notice, right, or aforesaid. Or the last condition is during the pendency of any conciliation proceeding before a conciliation officer and 7 days after the conclusion of such proceeding, right? So during the pendency of any conciliation proceeding, if there is any conciliation proceeding going on, so during that pendency or before conciliation officer, before that conciliation officer, and 7 days after the conclusion of such proceeding. So after 7 days, once the that proceeding has been concluded, a conclusion has reached, all the things have been sorted out. So after that, 7 days after the conclusion of such proceeding, right? Okay. Now let us see what are the procedure of lockout. So the procedure as per section 22 clause 2, no employer carrying on public utility carrying on public utility service shall lock out any of his workmen. So what are the conditions, right? So without giving them notice of lockout as herein before provided within 6 weeks before lockout. So they should be within 6 weeks before lockout. Within 6 weeks, a notice has to be given to the employees, right? Within 14 days of giving such notice, or within 14 days of giving such notice, right? It is just like the whatever the conditions we have seen above in the this strike. So we will find this similarity between the same, right? So both are quite similar. Now let's move further. It is before the expiry of the date of lockout specified in any notice as aforesaid. So before the expiry of the date of lockout, so whatever the date before the expiry of the date of lockout, which is specified in such notice, right? So before that date expires, right? During the pendency of any during the pendency of any conciliation proceeding. So if there is any conciliation proceeding which is going on, right, before a conciliation, and that is before a conciliation officer, and 7 days after the conclusion of such proceeding, right? So which is 7 days, and after the conclusion, right, after 7 days. Okay. Now let us see legal strikes and lockout. What are legal strikes and lockout? So whatever conditions which we have discussed, both the conditions are almost are same, just like the strikes and lockouts. As we have discussed, strike is from the side of the employee, and lockout is done from the side of the employer. Okay, let us see. A strike or lockout shall be illegal. A strike or a lockout is illegal if employer or worker whoever disobeys or fails to follow section 22, 23, 10 clause 3, 10A, 10A, 4A for commencing strike or lockout. Those strikes and lockout are said to be illegal. So these are if strike or lockout is not as per the section 22, 23, 10 clause 3, 10A, 4A, so that will be illegal, right? So all the conditions are mentioned over there. So let's see what does section 22 say. It says section 22 provides prohibition of strike and lockout. So it talks about prohibition of strikes and lockout. Here notice is mandatory in public utility service. So as we have discussed, notice, right, 14 days, 6 week. So all the notice, that mandatory period, so that notice should be given within that period, right. And section 23 provides general prohibition of strikes and lockout. So section 23 talks about general prohibition of strikes and lockout. If said matter is pending before board, labor code tribunal, national tribunal, arbitrator, as mentioned in the section 10, 10a, or settlement or about is in operation, right. So these are the things. These are the provisions on the basis of which a strike or lockout may be termed legal, illegal, right. So let us see what the section 24 clause 3 says that a lockout declared in consequence of illegal strike or a strike declared in consequence of an illegal lockout shall not be deemed to be illegal, right. So it says if there is any lockout which is declared in consequence of if there is any illegal strike going on, right, and on the basis of that, if there is any lockout, right, so that shall not be deemed illegal. Okay, so that will not be deemed illegal. Okay, so what are the penalties for illegal strike and lockout under the act? So penalty for illegal strikes and lockouts are any workman who commences, continues, otherwise acts in furtherance of a strike which is illegal, right, under this act shall be punished with imprisonment for a term which may extend to one. So there is imprisonment of 1 month imprisonment or with fine which may extend to 50 rupees or with both, right. Either there is 1 month ongoing illegal strike, either there is 1 month imprisonment or 50 rupees fine, right. Now any employer who commences, continues, or otherwise acts in furtherance of lockout which is illegal under this act shall be punished with imprisonment for a term which may extend to 1 month or with fine which may extend to 1000 rupees or with both, right. Here the difference is there. The fine is 50 rupees for the employee and 1000 rupees for the employer, right. And the imprisonment is same for both employer and employee. What are layoff and retrenchment and the essentials? So let us see what do we mean by layoff. Layoff has been defined under section 2 clause K of Industrial Dispute Act 1947. Thus layoff means the failure, refusal, or inability of an employer on account of his shortage of coal, power, raw material, or the accumulation of stock, breakdown of machinery, natural calamity, for any other unconnected reasons, to give employment to a workman whose name is borne on the muster roll of his industrial establishment who has not been retrenched. So either that person has not been retrenched. Layoff. So these are the conditions. On what grounds? Number one, shortage of coal, right. This layoff can be done on the shortage of coal, raw material, accumulation of stock, right. Breakdown of machinery has been broken down, natural calamity, if there is natural calamity. So the definition is self-explanatory, right. Or any unconnected reason to give employment to a workman whose name is borne on the muster roll. So that person should be on the muster roll, right, of his industrial establishment. Okay, and that person should not be retrenched. So thus the following are the essentials of layoff. So let us see. There must be a failure, refusal, or inability on the part of the employer, right. So there should be failure or refusal on the part of the employer, right, to give employment to a workman. The failure, refusal, inability should be on account of shortage of coal, as we discussed above, power of raw material, shortage of coal, power or raw material, accumulation of stock, breakdown of machinery, natural calamity, or any other connected reason, right. The workman name should be on the muster roll of the industrial establishment, right. So the workman name should be on the muster, right, that should be on the muster roll of the industrial establishment. Okay, the workman should not have been retrenched, and the condition is that should not have been retrenched. Okay, retrenchment. So let us see what do we mean by retrenchment. Retrenchment is something akin to downsizing, right. When a company or government goes through retrenchment, it reduces outgoing money or expenditure. So it means it reduces the outgoing money or expenditure or redirects focus in an attempt to become more financially solvent. Many companies that are being pressured by stockholders or have had flagging profit reports may resort to retrenchment to shore up their operations and make them more profitable. So if there is any, if the profit is going down, so in order to reduce that, in order to just reduce that, if the companies, if the industry is incurring some losses, so in order to just reduce that losses, so to make it more profitable, so this retrenchment thing is done. Downsizing, it means just reducing the number of workmen, reducing the number of employees working in the industry, right? Now let us see what the section 2002 clause 00 says of the Industrial Dispute Act. It defines the retrenchment. So retrenchment means the termination by employer. It is the termination by the employer of service of a workman. So it is the termination, right, where the employee has been terminated, right, for any reason whatsoever. So the reason may be whatsoever, otherwise than as punishment otherwise than as a punishment inflicted by way of disciplinary action, but does not include. So it should not be by way of the disciplinary action, but does not include voluntary retirement of the workman. If the workman has taken voluntary retirement, so that will not be retrenchment. Retirement of the worker on reaching age of superannuating, if the workman has reached the age of superannuation, if the contract of employment between the employer and the workman concerned contains a stipulation in that behalf. So if there is any stipulation, any term on the basis of which the workman is doing is doing all those things, is just voluntary retiring from the service, so that will not be termed retrenchment. Okay. Termination of the service of the workman as a result of non-removal of contract. So on the basis of non-removal of there is non-removal of the contract of employment between the employer and the workman concerned on its expiry. So the contract has expired, of such contract being terminated under stipulation, and when that the contract has been terminated under stipulation, and the terms are such on the basis of which the contract gets terminated, in that behalf content therein, right? Termination of service of workmen on ground of continued ill health. If on the basis of ill health the termination is there, so that will not be retrenchment. The definition of retrenchment was not included in Industrial Dispute Act 1947 in its original form. So it wasn't initially it was not included in its original form. It was inserted by amendment of Act in 1953. So there was amendment in 1953 on the basis of which this term was included. The Bombay High Court in State of India versus Sundramani held that wherein the court held that an analysis of the definition reveals 4 essential ingredients. So let us see what are the 4 essential ingredients. They must be termination of the service of workman. So there should be termination. The service of the workman has been terminated. The termination must be by the employer. So the employer has terminated for any reason whatsoever, right? Otherwise than as by way of punishments. So there should not be any punishment, right? Inflicted by disciplinary. So there should be not punishment because of the disciplinary action. Okay. What are the industrial establishment? Now let's move further. Let us see important issue in this. This important point which will help us to understand what industrial dispute introductory part of the Industrial Dispute Act 1947. This is what are the industrial establishments where provision of Industrial Dispute Act 1947 relating to layoff and retrenchment compensation do not apply. So we are going to see some of the establishment where this layoff retrenchment compensation do not apply, right? So it is section 25 of the Act provides clearly that provision of the Industrial Dispute Act relating to layoff and retrenchment compensation do not apply to 3 types of industrial establishments. So these are the 3 industrial establishments where this layoff retrenchment compensation do not apply, right? This Industrial Dispute Act which is relating to layoff retrenchment compensation, it does not apply here. An industrial establishment in which less than 50 workmen on an average per working day have been employed in the preceding calendar year. So where the number of employees are less than 50, right, in the preceding calendar month, right? Industrial establishment which are of seasonal character. So where the establishment which are working on a seasonal basis, like season to season, like the rainy season, like on the basis of like there are some seasons, right, or which performed only intermittently, right, which is either seasonal in character or intermittently, right? Industrial establishment to which chapter 5B applies as inserted by the Industrial Dispute Amendment Act 1970. 6. So as per the chapter 5b of the Industrial Dispute Act, so these provisions do not apply over there, right? Which is layoff and retrenchment compensation, right? Relating to layoff and retrenchment compensation. So these are the three categories of the industries where it does not apply. What is now the next issue is, the next point is, what is referred as continuous service in regard to layoff compensation. So what do we mean by continuous service? The right to compensation under act accrues to a workman only if, so the right to compensation that accrues to a workman, so a workman is entitled to right to compensation only if he has put in at least 1 year of continuous service. So there should be at least 1 year of continuous service, right, on the basis of which he will be entitled for the compensation under the act. Section 25b defines what amount to continuous service. So as per 25b, it defines what do we mean by continuous service. A workman is said to be in continuous service if he is for that period in uninterrupted service. So there should not be any there should not be any interruption, right? It should be uninterrupted service. Okay, now let's move further. Interruption on account of sickness, authorized leave, an accident, a strike which is not illegal, a lock and cessation of work which is not due to the fault of workman should not be taken into consideration for calculating the period of continuous service. So if the interruption is because of the sickness, if there is any sickness, so because of that there is interruption, right? If there is any authorized leave, right? So if there is any if there is any accident, as a strike which is not illegal, right? And there is any a lock and a cessation of work which is not due to the fault of so that is not due to the fault of the workman, so that will not be taken into consideration. So these things will not be taken into consideration while calculating the period of continuous service. So it is not going to work as interruption, right? So it will not be deemed interruption. Okay, so even if a workman has not been in continuous service for a period of 1 year, he shall be deemed to be in continuous service for the period of 1 year if he satisfies the following two conditions. So there are two conditions, right? If the workman satisfies these two conditions, right, then he shall be deemed to be in continuous service, right? Okay. Now let us see the conditions. He was in employment for 12 calendar months preceding the date with reference to which calculation is to be made. It means he was in the employment for 12 calendar months, right, preceding the date. So he should be working for continuously for 12 calendar months. During such 12 months, he actually worked for not less than 190 days. So he should be working for 190 days. In the case of employment in a mine, if he is working in a mine, so that should be not less than 190 days, and 240 days in any other case. So the condition is 190 days in mine, where a workman is working in mine, and 240 days in any other cases, right? So as we've already, so what are the interruption? So if there is an interruption on account of sickness, authorized leave, so that will not be taken into consideration, right, for calculating the period of continuous service. Okay, as we have already discussed. According to the explanation of this section, for the purpose of calculating the number of days on which a workman has actually worked under an employee, the following days shall be included, right? So these are the days which are going to be included, right, in order to calculate for the number of days he has actually worked. So let us see what are the what are the days. The days on which he has been laid off under an agreement or standing orders under this act or any other law applicable to the industrial establishment, right? So the days on which he has been laid off, right? So it says for the purpose of calculating the number of days on which a workman has actually worked, right, under an employer, the following days shall be included. So these are the days which are going to be included, right? So the days on which he has been laid off under an agreement. So when he has been laid off under an agreement, there is an agreement on the basis of which he has been laid off, or standing orders under this act, right, or under any other law applicable to the industrial establishment, where on the basis of any terms, on the terms of the contract, where it is from the side of the employer, where employer has laid him off. So there, that those days will be counted, will be taken into consideration, right, while calculating the actual worked, where he has actually the number of days he has actually worked, right? The days on which he has been on earned leave. So if the employee is on the if the employee is on the earned leave, so even that will be taken into consideration, right? On the number of days he has worked, actually has worked, the days on which he has been absent due to temporary disablement. So the days on which he has been absent due to temporary disablement due to an accident arising out of in the course of his employment. So if during the course of employment, if the workman meets with an accident, so that will be taken into, so there he will be considered that he has actually worked, right? So even that will be taken as a case where will be taken as where he has actually worked. Now let's move further. So and in the case of female worker, the days on which she has been on maternity leave not exceeding 12 weeks. So in the case in the cases of maternity leave, if it is not exceeding 12 weeks, so even that will be counted, right, as the number of days actually worked, right? So these are the things which we have covered, and these things will really help us to understand what are the terms on the basis of which any dispute, any concern of the the workman is taken, concern of the workman is taken care of, right? So with this we have come to the end of this video, and rest things we will discuss in the next lecture. Thank you very much.